Hi, dear students. I am Ömer Ali Gergin, and I am a research assistant in Anadolu University Faculty of Law in Civil Law Department. I am here to explain you the Introduction to Law and Chapter 6, Introduction to Civil Law, which is my department. And after this chapter, we will learn the following subjects: the concept of civil law, the basic unit of the society, which is the family, and law obligations. We will learn basic terms about these topics. Okay, let's begin with the concept of civil law. Civil law mainly governs the relationship between individuals. This is very important sentence because, as we saw before, the administrative law concerns the relations between individuals and the governments. Uh, or, for example, international law is about the relations between states, between governments, and criminal law concerns about crimes, punishments, and prison sentence or death penalty. And here is civil law, and its main concern is the relationship between individuals. Very important one. Civil law covers all aspects of the life of an individual from birth till death. Even after death, all the issues are regulated by civil law. Uh, uh, if you think about it, law of succession is about after death. So civil law uh, has a very large affection area. Okay, there are five main sub branches of civil law. These are law of persons, family law, law of obligations, law of succession, and law of property. Okay, so we will see now the law of persons, and persons are two kind: real persons, they are actual human beings, VR, and legal persons. Every person has capacity to have rights and duties. It's a passive capacity, and just being a real person is enough to have this capacity. In legal history, there were people such as slaves who were not the subject of legal rights or whose rights were limited. In the modern legal system, the principle of equality is governing the capacity to have rights and duties. Capacity to act is, on the contrary, an active capacity. A person who has capacity to act has the capacity to acquire rights and incur obligations through his or her own actions. This capacity includes both the capacity to enter into legal transactions and the capacity to be liable for tortious liability. Since it's an active capacity, it doesn't enjoy the principle of equality, and there are four groups of persons according to their capacity to act. They are persons of full capacity, limited incapacity, and full incapacity. The second sub branch of the civil law is family law, we said before, and family is the basic unit of in the society. Therefore, not only with the civil code but also in the constitution, great emphasis is granted to the family and to the protection of the family. According to Turkish Civil Code, only engagement and marriage are the sole legally accepted unions. Engagement is not a registered relationship, whereas marriage is a registered relationship. Divorce, on the other hand, is a way to terminate the marriage by a court decision. In Turkish legal system, only the judge is entitled to grant a divorce decision, and in order to bring an action for divorce, the spouse should have a grant for divorce that is counted in a limited number in the civil code. But if both spouses want to divorce, and if they may agree on all aspects related with divorce, there is a simpler way of divorce named as uncontested divorce. In other saying, agreed divorce, in which again the decision of the judge is a necessity. So, even if if the married couple agrees on divorcing, they still have to go to the judge and get a decision, get a divorcing decision. Okay, let's continue with the law of obligations. Law of obligations is the branch of civil law particularly concerned with the relations that create obligations. These relations are actually very important for everyone, and even in our daily lives, every day we enter into these kinds of relations, mostly without recognizing the legal meaning and significance. The main source of law of obligations is the Code of Obligations. The Code of Obligations is composed of two parts. The first part is called General Provisions, and the second part is called Specific Types of Contracts. So, what is an obligation? An obligation consists of creditor, debtor, and consideration. Creditor is the party who can request the consideration. The debtor is the party who has to realize the consideration, obligated one, and consideration is an act which the debtor is obligated to perform as the content of her obligation. What are the sources of obligation? Let's see. Contracts, torts, and unjust enrichment. A contract is a legal transaction concluded by a mutual exchange of assents of two or more persons. When a person acts beyond the restrictions of law, the acts become wrongful, and such wrongful acts are named are torts. And last one, the third one, unjust enrichment is a gain acquired in an unjustifiable manner out of the property of another person. So, let's see what are debtor, creditor, and consideration. A debtor is in default when he delays the performance of an obligation which is already due. Therefore, when an obligation is due, the creditor may put the debtor in default by demanding the performance. So we finished this chapter. Thank you for listening.